Today's discussion or subject, which I was keen to discuss and speak about, is a subject which is central to the study of law and central to the practice of law. And it is central primarily because there is no substantive discipline of law which is complete without an understanding of the subject at hand, which is the interpretation of statutes. And it's therefore what we learn from the study of the interpretation of statutes, which is principles that have evolved from centuries. The leading judgment um, in the field of interpretation of statutes goes back to the year 1584 or thereabouts. So it's clearly it's a discipline which has evolved for 500 years and continues to evolve. Is what has shaped the way we are, the way we live, and it is these principles which have had a direct bearing on our society today as it exists. Um, I wanted to think of, before I get into the rules or the principles and the judgments, which I will do in due course, I wanted to perhaps put into perspective the power of interpretation of statutes before I delve into uh, the details of the subject. And I thought to myself that what better way of exemplifying the power of the subject of interpretation of statutes than to make reference to the manner in which the Supreme Court and various courts have interpreted the Constitution of India. And of course, I'm not going to confine myself today only to the interpretation of the Constitution, but I thought that this was an apt opening into the subject, which is take an article of the Constitution as simple in its language as Article 21. It's really the heart and soul of our Constitution, and it secures to all persons the right to life and personal liberty. And just those words, life and personal liberty, have been the subject of such extensive interpretation and construction by the courts, and their evolution from the 1950s to the 2020s or 2000 now 2020, over the last 70 years, is in itself an illustration of how the courts have, keeping in mind that the Constitution is such a dynamic and social document, keeping in mind the different times in which we've lived, and keeping in mind the different problems that people have faced, how the courts have interpreted, or by a process of interpretation, given such vigor and vitality to those words life and personal liberty. Way back in the 1950s, the leading judgment in the case of A.K. Gopalan took a very narrow view of these words. It said life and personal liberty is precisely that. It is just life means to live, and personal liberty means bodily freedom. And yet, over a period of time, the courts have eschewed that narrow construction. And now, today, it's because of the interpretation and construction of those words that the Supreme Court has held that the right to life means the right to die in Aruna Shanbag's case. The Supreme Court has said that the right to life means a right to life with dignity. And if it means a right to life with dignity, concomitant to dignity would be, for example, the right to work in a workplace without the apprehension and fear of sexual harassment. That's the Vishaka judgment. The Supreme Court has said in a number of judgments, the MC Mehta line of cases, all in Vellore Institute or in Pune Municipal Corporation, that life means clean environment. And so you can get the drift of where I'm going with this, that it is by a process of constitutional interpretation that the word life has branched out into so much more. It means the right to sleep. It means the right to education. It means the right for pavement dwellers in Olga Tellis's case to have shelter. It's the right to food. It's the right to a road. And that is really the power of interpretation. And of course, it's equally applicable when we talk about interpretation of statutes and legislation, even other than the Constitution, as I will go on to illustrate. And when I give these illustrations, I mean to give illustrations of both the good and the bad. The line of judgments within Article 21 have generally been so expansive in their interpretation of this core of the Constitution that it has only inured to our benefit. But let me, as an opening, also give you an example which is very close to my heart of an interpretation or a process of interpretation by the Supreme Court, which, when I look back at it 15 years later or 14 years later, I think to myself, many of the problems that we face today as a city would perhaps have been avoided had the Supreme Court taken a different view of the interpretation of a statute or a legislation. And the example that I have in mind is that early on in my career as a counsel, I had the good fortune to be involved in the landmark Milllands judgment. I think for most people living in the city of Mumbai, you would be familiar with the Milllands judgment. And that's really, today we talk about, we are exposed to many judgments where the monetary value and stakes of judgments run into billions of dollars. But this was a case which came into life sometime around 2004, 2005. And the commercial value involved in this matter was enormous. It ran into billions of dollars, and there weren't many cases, even in a commercial city like Bombay, of that magnitude. But keeping the commercial value aside, let me tell you what has been 15 years down the line the effect of an interpretation placed on regulations by the Supreme Court. The whole debate in that matter was that cotton textile mills in the city of Mumbai had long since been defunct because the industry had suffered on account, for various reasons, on account of very harsh labor practices. Harsh meaning harsh against the industrialists. Also the fact that India was facing competition from Bangladesh, Sri Lanka, Vietnam. And in the 1980s, these mills went defunct. Management was taken over, these mills were acquired by the government, but it didn't result in any industrial activity resuming. And yet these mills in the heart of Mumbai, which occupied collectively, there were about 20 odd private mills and a similar number of NTC mills. They occupied a land area of about 600 acres in the heart of Mumbai. And the development control regulations, which was the subject matter of interpretation, and specifically a regulation called Development Control Regulation 58, fell for interpretation by the Bombay High Court and the Supreme Court. And the whole issue in that matter, which was very largely a matter of interpretation, the issue was that when the private mill owners were being given an opportunity to convert their user, the user of those mills was industrial. It was covered by what is known as I2 and I3 zones. The debate on interpretation in that matter was that when you convert those mills from industrial to commercial or residential, what percentage of the land area upon which the mill structures stand must be made available for public purposes, and what percentage of that land area will now be able to be utilized for residential or commercial purposes. And the entire matter turned on the interpretation of what is open land within the meaning of DCR 58. The interpretation that the Bombay Environmental Action Group was placing on that regulation, and right now I'm not getting into the merits of the interpretation, I'm only trying to highlight the importance of the process of interpretation to, let's say, the life of a city or the life of society. In this case, the life of city and society. So what the BEAG, for whom I was the junior most counsel, led by very eminent lawyers, was canvassing was that when these percentages are to be worked out, we have to look at open land as it is understood after the existing mill structures are demolished. So if a mill stands on 1 acre, and out of that 1 acre, 90% of the footprint is consumed by old dilapidated mill structures, and you want to take advantage as a mill owner of this clause, which allows you to convert the user and revive an industry which is otherwise defunct, you have to give up a percentage of open land on the basis of the entire mill area land. The argument on the other side was no, that open land must be understood as the small fragments of open land as they exist and open to sky after taking into consideration the footprint area presently occupied by the mill structures. I'm not getting into the minutiae in this matter. I'm only giving you an overview. We succeeded in the Bombay High Court and we lost in the Supreme Court. And the Supreme Court took a view that the mill owners were correct and the land that was to be made over for public purposes, for open spaces, for public utilities, and to be given to the city, of course, against the grant of FSI and TDR, is not 1/3 of the entire open land, but it is 1/3 of these small fractions of open land. And now when I look at what has happened to the city and to the Lower Parel or the Parel area and the city as a consequence of that decision of the Supreme Court, is that you have had a proliferation of development. It is today one of the most congested and trafficated areas of the city of Mumbai. It comes as no surprise to me and to some of my colleagues who appeared with me in the matter or with whom I appeared in the matter, that the density of population in Parel as a result of this proliferation of commercial and residential development, and of course the slum areas which have always existed there, is so high that far from being able to achieve the objective of Parel giving the city of Mumbai the opportunity to give unto itself an open space like the Central Park or equivalent to the Central Park, something that a city would hardly ever get in its lifetime, the opportunity to grow a green lung many, many centuries after a city itself has come into existence. But that opportunity was lost. And I think for worse, there are others who think for better. But the point that I'm trying to make is this is the far-reaching impact of the process of interpretation of statutes. That is what was the consequence of the Supreme Court interpreting a relatively obscure provision like DCR 58. And it's an interpretation which is going to stick with the city for centuries to come. Now, with this, just as an overview of why this subject is so clearly important to us, and before I get into some of the theory, because I must touch upon some of the theory before, as part of today's discourse, I wanted to also tell you something very interesting in my mind, which is that when I have looked at judgments either in the course of my preparation for matters or looked at judgments for the purposes of preparing for today's webinar, what I found fascinating is that many of the times the expressions, the words, and the phrases that have vexed the court in the process of interpreting a given statute are words and phrases that are so commonplace and that we use so frequently in our regular conversations. But when we use them in our regular conversations, they hardly give rise to any misunderstanding between two people. I mean, perhaps they may give rise to misunderstanding between two lawyers, but that's a separate story. And I think that lawyers, for all their legal discipline, have contributed to the confusion rather than contributing to the solution. But let me give you examples of some of the words as bare phrases or bare words which have been the subject of judgments, or which are the kind of words which we understand very clearly, but sometimes the courts will never find it as clear as that. So just some examples: open space, age, wife, husband, premises, but, committee, and, prize. So these are some words which I will of course discuss again in the context of certain judgments, but which have fallen for interpretation and caused confusion. Now, before I get to the judgments, let me play around with this whole idea of communication with these words and what it can mean to people, to reasonable people, to ordinary people who possess an average understanding of the language of English. And let me explain to you by way of normal conversations why this subject is so exciting and so interesting. Now, take an example. You go to a friend's house in India or in Bombay, and he offers you a drink. And your response is, I'm going to have a whiskey and soda. Now, we know in India, especially amongst the Sindhis, but I'm sure it cuts across all communities, whiskey and soda, it's very clear. Whiskey and soda, it's a combination which is well known, and it's hardly likely, or let me put it differently, it's extremely unlikely that your host is going to wonder to himself that does whiskey and soda actually mean whiskey or soda? It's not going to be much confusion to him. It's going to be very clear to him that you're going to get a little bit of whiskey, soda, and ice. That's how it works over here. And the word and means what it's always meant, which is I want this along with this together. But let me take this particular illustration and switch it around a little bit. I'm sure, like many of you, myself, traveled to the US, where it's extremely unusual for them to have their whiskey or their scotch with anything. And when I go there, I'm a teetotaler, but my wife isn't. And oftentimes we're there and we're entertained by, or we're in the company of Americans, and they ask her, what do you want to drink? And she'll say, I'll have a whiskey and Coke or a whiskey and soda. And they look at her extremely quizzically, because in the US, whiskey is had with nothing or a scotch is had with nothing. And therefore, when she says to them, I want a whiskey and soda, their natural instinct is to look at, or to hear that sentence and think to themselves, I'm sure she meant that she will drink a whiskey or soda. And soda in the US, as you all know, is really a soft drink. So you change the setting, you change the geography, you change the social customs and traditions. And something that is so clear in its meaning and import in India, whiskey and soda, means something quite different, or could well be understood. And even if you ultimately get the drink that you want, which is whiskey and soda in the US, it's not without having to explain and justify why you should get a whiskey and a club soda. So the word and in this context in India doesn't admit of any ambiguity. But the word and in the same sentence, when spoken in a different geography, gives rise to tremendous ambiguity. That's one example. Let me give you another example. I have a 9-year-old daughter, and third generation of, she is that I am the third generation of lawyers in my family. She will be the fourth if she pursues that. When she's sitting down for dinner or lunch, and my wife is over there, and she asks my wife, what do I have to eat? And my wife explains to her in simple English, you're going to eat your vegetables and your chapati. And I'm looking at my daughter's face, and my wife has made it extremely clear that she's going to eat vegetables and chapati. But as those words are being spoken, my daughter is processing it as vegetables or chapati. Let me again give you, using my family as a point of reference, another example. You take her to a toy shop, and I'm going to now add a variant to this conversation to make a point. And my daughter goes to a toy shop, and as always with all kids, what does she want to do? She wants to buy as many toys as possible. And some of these examples are examples which have occurred, but I'm trying to tailor them to some of the issues that have arisen in judgment. So you take my daughter or any child to a toy shop, and a parent admonishes them preemptively at the beginning of a shopping expedition and says, the wagging finger, that look here, Amira, We have no space at home. You are going to buy only one toy. You can either choose this or this. What is that sentence being processed, or rather, how is that sentence being processed by the listener? And the listener is processing it in multiple ways. One way of processing it is the background has been given to me, and the background and the context is we have no space at home. That's the background. This instruction, this admonition comes with a background that we have no space at home. And in the context of that background of small house and no space, my mother has told me you are either going to buy this or this, meaning you're going to buy one toy, this or this. So the instruction, when looked at, is quite clear. One toy and one toy alone. But there's another way of looking at it. And the other way of looking at it from the point of view of a listener is that the whole purpose of this instruction and this restriction of one toy is because we have no space at home. But if that is the overarching objective of this instruction, I know a way to get around it. All I need to do is to buy two toys which are small in size, because if I buy two toys which are small in size, I will still be achieving the objective of not buying something which will not fit into my house or which will not be accommodated in the lack of space at home. So then again, in this normal conversation, you have two ways of looking at it. If you look at it purely from the point of view of the instruction and forget the context, it's clear. Choose one toy. But the minute you bring the context into it, does it not admit itself or allow for a different perspective, which is, I'll buy as many toys as I want. I could buy 5, I could buy 6, so long as they are small in size and they can be accommodated in a limited space. And one last illustration before I end. And this, I must tell you, has happened over and over again in my life and in the course of my interactions with my wife. We go abroad, and I'm a terrible shopper, and it puts me into a terrible mood. And my wife, on the other hand, enjoys it like most normal people do, especially when you don't get too much of an opportunity over here. And we're walking on Oxford Street in London or any other popular shopping venue, and I'm exasperated. And we get to the last shop for the 4th time in the evening. And my wife says, okay, I'm going to go inside over there and I'm going to shop for 1 hour. And I look at my watch, as grumpily as I can. It's 5 in the evening. And I think to myself, she's going to shop for 1 hour. I'm going to show back over here at 6 in the evening. And that's the end of a long and tiring day. And I get back to the entrance of the shop at 6 in the evening. And there's absolutely no sign of her. None whatsoever. I mean, I'm looking around to see, and then my mind starts playing tricks on me. And everyone who looks remotely Indian and is 5 foot tall starts appearing to be my wife, but she's not. And then my wife comes out of the shop at 7 in the evening, happy and not a trace of remorse. And it's just the perfect setting for a marital squabble. And I try and bite my tongue and say, forget about it, but I can't. And then we launch into this quarrel with each other. And I'm there saying that, I mean, how can it be that 1 hour of shopping from 5 o'clock is 7 o'clock? By what stretch of the imagination and by what understanding of English can 1 hour be 7 o'clock? And to which her response is that the shop was so crowded that I had to wait for 1 hour in the line to get into the trial room so that I could try the clothes that I bought. And surely when we said that I would be shopping for 1 hour, we didn't mean that I would be in the shop for 1 hour, standing in a queue for 50 minutes and shopping only for 10 minutes. So therefore, when we say shopping for 1 hour, it actually means shopping for 1 hour, and you necessarily have to exclude all the time that I spent inside the shop not shopping. So this, my friends, as part of normal conversation, puts into perspective how words which are clear or which we think are clear, but when looked at in a certain context, looked at in a certain background, different geographies, different objectives, subjective and objective, can lead to many different ways of understanding them. Therefore, with this preface, and you might feel that I'm trivializing the subject, but the truth of the matter is that when we get into an analysis of the judgments, you will find that it's exactly this multitude of approaches which has led to the courts being vexed and much time being spent by judges and in judgments exploring what was actually meant by words which at first blush seem fairly clear.